Good morning, everybody, and good evening to everybody. A warm welcome to all of you joining us this Sunday. It's fantastic to see such a mix of participants from maritime industry professionals to legal experts to students and researchers from across the globe. Before we get rolling, just a few quick notes. Please keep your microphones muted during the talk to avoid the background noise or disturbances to the speaker. You may keep your cameras on. If a question pops into your head at any point, drop it straight to the chat. We'll be picking them up for our QA segment. We have two Q&A segments. There are two different topics which Sir would be taking, and we would have Q&A after each of those. And yes, for those asking, if you stay with us until the end and when we wrap up, you will a certificate of participation upon filling out the feedback form. We're about to unpack a topic that is front and center in today's maritime world, the Great Amanda and the EU Emissions Trading Scheme, legal insights for charter parties. Environmental regulations isn't just knocking on the shipping industry's door, it's already here. With the EU Emissions Trading Scheme now extended to maritime transport, the rules of the game have changed. We are talking compliance cost, reporting requirements, and contract clauses, which could make or break commercial relationships. The Great Amanda case is a perfect starting point to understand how these obligations play out in practice. It is more than just a case, it is a real-world example of how courts are interpreting risk, responsibility, and liability in this fast-changing landscape. By the end of today's session, you'll walk away knowing what the Great Amanda case was all about and why it matters, how the EU ETS applies to shipping, and what that it means for your contracts. The must-have clauses, considerations for charter party agreements, and the common pitfalls and disputes to watch out for and how to avoid them. For students especially, this is a golden opportunity to see legal principles in action and to understand the kind of challenges shipping lawyers are solving right now. And to guide us through it all, we couldn't have a better expert. It's my absolute pleasure to introduce Professor Simon Baughen, Professor of Commercial Law at the Institute of International Shipping and Trade Law, Swansea University. Professor Baughen studied law at Oxford, practiced maritime law for almost a decade, and has spent the last 3 decades shaping the way shipping law has thought and applied around the world. He is the author of Shipping Law, now in its 7th edition, and the current author of Summerskill on Laytime, the go-to reference for practitioners. His expertise also bridges into environment and human rights law, and his book Human Rights and Corporate Wrongs was cited by the Supreme Court of Canada in the landmark Nevson versus Araya case. So when it comes to connecting legal theory, real-world practice, and global regulatory change, we are in the best possible hands. Sir, it is a privilege to have you with us today. The floor is yours.
Thank you very much for that kind introduction, and thank you very much for inviting me to give this presentation. There are going to be 2 talks, but there is a link between them, and I'll explain that as I go through the first presentation, which is about the ETS, the European Union's Emissions Trading Scheme, and shipping, which has been brought within its ambit as of the beginning of 2024. After that, and we'll have questions on the presentation directly after this one, and then there would be a second presentation about the is it the Great Amanda or the Grand Amanda? I can't remember, but we'll find out. This is a very recent case. I was advised by Professor Tettenborn on the 31st of July as I was travelling down from Edinburgh to York on a train journey, that there's this interesting case, and don't worry, the judge doesn't agree with your comments you've made in articles about the indemnity. He's been comparatively kind. Well, I hope that when I go through the Great Amanda case, I can return the compliment and be tolerably kind about my comments on the judge's decision in that case, which I'm not sure I agree with. And I think it's actually quite an important case about the nature of the implied indemnity under charter parties. So I'm going to start now with my first topic, the emissions trading scheme and shipping. And I'm going to be concentrating on enforcement mechanisms and jurisdictional issues. And we'll be looking at some of the contractual issues which come out of this inclusion of shipping into the ETS. And in particular, some rather peculiar public law provisions which the EU has put into its directive to try and shift the cost of acquiring emissions allowances from the ship owner to the time charterer. And I'm thinking of various ways in which you might avoid that happening. Now, I'm going to see if I can, right, I'm going to have to, I think to begin with, I have to, I haven't got my main slides up, yeah. So I'll be going on this screen. I think you can still see me, but I'm not sure I can see myself or anybody on my screen. But this will enable me to click through the slides, which I am sharing. So one of the things we're going to look at is what is called the pass-through. There's a provision in the EU ETS directive that the shipping company can pass down to the time charterer, and member states are meant to provide for this under their national laws, the costs it's incurred in obtaining emissions allowances because of its trading in the EU. So first of all, we're going to look and just see what has happened with the revised emissions trading scheme directive. It came out in the summer of 2023. There's the reference to the directive. It amends the previous ETS directive and also makes some amendments to the monitoring, reporting and verification regulation of 2015. As from the 1st of January 2024, shipping entered the European Union's ETS, the emissions trading scheme. There's going to be an initial phased entry, and the scheme is that for voyages within the EU, there would be 100% emissions allowances which would have to be purchased. Basically, one allowance for 1 ton of carbon emitted during that voyage. The cost of the allowance is variable. The current cost is 62.08 euros, but it has been as high as 97.50, which is at the end of 2024. Now, many voyages are going to go into the EU from an external place. Supposing you've got a voyage from India through to Rotterdam, that's an extra EU voyage. So for that voyage, you have to, you have a liability, the ship owner will have a liability to buy half the amount of emissions allowances. It's a 50% charge for verified emissions of carbon, and that will change, I think, in 2026 or perhaps 2027. That will change to include other greenhouse gases such as methane. There is a phasing in. So for the year 2024, it's 40% of those required allowances which the ship owner is going to be stung with. Then in 2025, this calendar year, it's 70%, and then next year we get up to 100%. But remember always that there's this difference between 100% for voyages which are entirely within the EU, and anything which involves the EU but has got an element outside the EU. That's going to be 50% for the whole amount of carbon emitted on that voyage. Now, who bears the cost of acquiring carbon allowances? It's the shipping company, and this is the initial definition. So it's the ship owner or any other organization or person, such as the manager or the bareboat charterer, which has assumed responsibility for operating the ship. and has agreed to take over all duties and responsibilities under the International Management Code for the safe operation of ships. So really, we're talking about ship owner, demise charterer, or ship manager. Now, one of the things which happened in the autumn of 2023 is the Commission introduced an implementing regulation. Prima facie, the shipping company will be the ship owner. It will be the registered owner unless there's a clear written delegation to either the demise charterer or the ship's manager. This delegation has to be provided to the relevant administering authority, and there's various bits of documentary proof which have to be provided, which the implementing regulation specifies. And if that doesn't happen, the ship owner is considered as the responsible entity. The first surrender of allowances, so you have to, you work out how much carbon, how many tons of carbon you used up on those voyages within or in and out of the EU. And then you work out what you have to buy by way of emissions allowances and then surrender them. The first year is 2024. So the first surrender of allowances actually takes place on the 30th of September 2025. So we're coming up to that very, very shortly. Now, the administering authority, this is the EU body which is going to ensure that the shipping company actually makes the surrender of allowances by the 30th of September each year. Now, that will be the member state where that is the flag state of the relevant ship. Now, if that's not the case, which is very likely to be the case, then it's the most frequently visited EU port state within the previous 4 years. And if you haven't had any EU visits within that time, the member state where a ship of the shipping company has started or ended its first voyage. And the EU Commission has provided at the start of 2024 a list of what ships have been assigned to what administering authorities. And they then have 40 days to open a maritime operator's account. The list gets upgraded every 2 years. If you're not on the list, you've got to open an account within 65 working days of your first call at an EU port. Now, there are penalties for non-compliance with the obligations to surrender allowances. And a failure in 2 consecutive years of surrendering allowances means that a vessel sailing to a port in the EU, if it's an EU flagged vessel, is at risk of detention. Otherwise, the risk is of exclusion from that port. And I would say that in that circumstance, the vessel will probably be unseaworthy if it's going to be subject to those, potentially subject to those penalties. Just looking at NYPE Clause 1, the owners are obliged to exercise due diligence to maintain the ship's class and to keep it in a thoroughly efficient state in hull, machinery and equipment for and during its service. The textbook on time charters, Wilford, suggests that thoroughly efficient state encompasses legal efficiency as well as physical efficiency. And if you're at risk of having these penalties imposed on you because you haven't surrendered your allowances as you should have done, I would say that you are not legally efficient and that your ship is unseaworthy. So that's one contractual way in which these obligations can affect parties under charter parties. Now, who is going to pay? The ship owner is the default. The registered ship owner is the default party to acquire and surrender the allowances based on the amount of tons of carbon used in voyages which concern the EU. Under a time charter, I don't think there's any breach of contract involved. I know the charterers under NYPE have to pay port charges or other usual expenses, but I think it's unlikely that would cover these expenses here. In a case called the Demetrius L, which I shall refer to again in a moment, the owners incurred a potential liability under the Grand Transportation Tax in the US, and that didn't fall under port charges or other usual expenses. It's something for owners to bear. Now, one thing which I'm going to be talking about when I talk about the Grand Demander is the indemnity, whether express or implied, which will operate in a time charter so as to give the owners an indemnity for any losses they suffer as a result of complying with charterers' employment orders of the vessel. This is the second string of the bow in the attempt to claim the liability of the ship owner for the transportation tax, which had been levied on it in the United States. They weren't able to do that. These were regarded as risks which had voluntarily been accepted by the ship owner at the date they concluded the charter. And we've got a quote from the judge here: "Owners are not entitled to recover from charterers under the indemnity the ordinary expenses and losses of trading, or those of which the owner has accepted the risk." And then there's a reference to the case of the Island Archon, which we'll look at in our second presentation. In the case of voyages to or from the USA, the transportation tax is an ordinary expense of trading and not an unusual feature. In any event, the risk of incurring or being liable for this very tax has been dealt with by a specific clause in the Charter Party Clause 112. And to the extent that owners are not entitled to recover under that clause, the risk of having to bear the cost of the tax is one which they must be taken to have accepted. Now, I think that makes it pretty clear that if you've got a standard time charter without any bespoke provisions to deal with ETS allowances, owners are not going to be able to recover those costs from the charterers. They're not going to be able to say, oh, you ordered us to do a voyage which either started in or ended in the EU, and because of that we've incurred a liability to surrender emissions allowances in respect of the amount of tons of carbon which we've emitted during that voyage. This is an ordinary trading risk which the ship owner will be taken to have voluntarily accepted as of the date of the charter. Now, one of the things I will do at the end of my second talk is to consider, well, is that the case now after the reasoning in the Grand Demander? We shall look at that in a moment, or a bit later on. Now, the pass-through. Ship owners are having to be in the firing line for paying for allowances and then having to surrender them each year, depending on how much carbon they've emitted, how many tons of carbon they've emitted during a voyage to or from the European Union. Under the directive, Article 3 GC, member states are required to take the necessary measures to ensure that when the ultimate responsibility for the purchase of the fuel and or the operation of the ship is assumed by a different entity than the shipping company pursuant to a contractual arrangement, the shipping company is entitled to reimbursement from that entity for the costs arising from the surrender of allowances. The party who is going to purchase the fuel and is going to determine the employment of the vessel is the time charterer. So that is requiring member states to have a provision in their national law which would enable a ship owner to recover from the time charterer what they've had to incur by purchasing and then surrendering EU allowances under the ETS. The problem is that unless you've got a specific clause such as BIMCO's ETS clause, which, surprise, surprise, requires the time charterer to purchase the necessary allowances, hand them over to the ship, and then hand them over to the shipping company, time charterer is not liable to pay for the cost of EU allowances. What I don't know is how far the EU member states have actually got in introducing that required national legislation. I haven't seen any data on that. And it's possible that it may never actually become an issue, and that's something I'm going to come to a bit later on in my talk. So I'm afraid that slide has duplicated itself. Now, supposing you're a ship owner, you're a shipping company, and you say, right, I am going to recover my EU allowances from the time charterer. Time charterer is not willing to do that voluntarily, so I'm going to sue them in the courts of a member state. Now, I think if the shipping company is the ship owner, there's a clear conflict with its contractual position under the time charter. And in that under the time charter, there's no provision for it to recover those allowances. Now, assuming that we're dealing with an English law clause in the time charter, and either English jurisdiction or London arbitration, we've got three possible responses. We could try and get an anti-suit injunction in the English courts against the ship owner if it then tries to commence proceedings in the courts of the member state to acquire a right of reimbursement from the time charter. Possibly arbitrate for damages, which are the cost of the allowances awarded in any foreign judgment. That, I think, actually is less possible now after the Court of Appeal's recent decision in one of the in the most recent case arising out of the Prestige oil spill. And finally, resisting enforcement of any judgment in England. Now, that wouldn't help you if you've got assets in an EU member state, but if the assets are in the UK or some other state, you should be all right. Now, unless you've got a reciprocal enforcement treaty, you'd only be able to get your foreign judgment enforced in the UK if either the defendant was present in that foreign country at the time the claim was served, or it had submitted to the jurisdiction of that country. Now, supposing that was the case, you could still challenge enforcement on various grounds. For example, you might say the foreign court didn't have jurisdiction according to the English rules. The proceedings were brought contrary to a jurisdictional arbitration agreement, or there's inconsistency with a prior judgment on the same subject matter and between the same parties. So if you jump the gun and get your arbitration award or a judgment with a declaration of non-liability for a claim by the owner against you, the time charterer, for the cost of EU allowances, that's something which could be a ground for not enforcing the judgment of a foreign court. Another party who could, subject to the necessary delegation, be the shipping company, would be a ship manager. Now, there it's a bit more complicated because you've got no contractual nexus between the time charter and the ship manager. This diagram shows the little arrowed lines showing what contracts there are. There isn't one between the time charter and the ship manager, but it may still be possible to resist enforcement on by one or other of the ways in which I've suggested. What about the availability of an anti-suit injunction? Now, you won't get this if the foreign claimant is a state. That's recently been confirmed in a claim involving an oil spill in Venezuela. What you have to decide is whether the person, whether the ship owner or the ship manager who is claiming in a foreign court in the EU, claiming against you for those allowances, is there a contractual or quasi-contractual link between you and that party? If there isn't, if there is such a link, prima facie it's going to be, you're going to get your anti-suit injunction. Because if you've got a contractual ground, you have to take all the provisions of the contract into account, including the jurisdiction provisions or arbitration provisions. If that's not the case, the time charter would have to show that the person commencing proceedings in another jurisdiction, that conduct is unconscionable. And usually you have to show it that it's vexatious or oppressive, or it interferes with the English court's due process, and that's more difficult. Arbitration, claiming damages or equitable compensation. After the most recent case in the Prestige, you're not going to get those damages. However, you can get a declaration of non-liability, and that would be useful in relation to number 3, resisting enforcement of any foreign judgment on the matter. And when I gave a presentation entirely about the jurisdiction provisions, I did consider briefly the position under the Hague Convention, which the UK has now acceded to and is now part of UK law. But I think basically this list of possibilities is really unaffected by that. Certainly you don't have the problem of anti-suit injunctions which you used to have when the UK was in the EU. There's nothing like that in the Hague Convention. Now, the sensible course is, instead of listening to Swansea academics saying how you can fight people if the ship owner or the ship manager is trying to get the cost of allowances by suing you in an EU state under this statutory pass-through, the sensible course is, why don't you agree in advance how these EUAs are going to be paid for? Get that reflected in the tripartite agreement with the ship manager if they are if there's a delegation to them as the shipping company. And you could, probably the most sensible thing would actually be to have an apportionment of costs. There are agreements available you can sign up to. BIMCO, surprise, surprise, its agreement puts everything on the time charter. And I've just a couple of things there. Everything is on the charters. They have to buy the allowances. They then have to surrender them to the owner's account or the ship manager's account, who then make the surrender at the end of September in each year of account. There's also the problem, the remedial problem about supposing you suffer loss as a result of expulsions from an EU port, or detention if you've got an EU flagged vessel, because the relevant shipping company, be it the ship owner or the ship manager, has failed to surrender allowances. Now, if the ship manager is the shipping company, there's an extra wrinkle to that, because they may have several ships under their management, and if they haven't surrendered allowances for one of those ships, but they've surrendered allowances for others, including your ship, you're still subject to these sanctions. So I think that would be a case where you would have a comeback, certainly against the ship owner. 17, 18. Other contracts. What about voyage charters? Well, the ship owner is responsible for fuel. There's much less scope for orders being given. There's no mechanism for the ship owner recovering EU allowances. BIMCO has 3 various contract forms available to deal with it. 3 different ways to get the voyage charterer responsible for EU emissions allowances. Unilaterally, the ship owner may respond to the EU ETS by saying, okay, I'm going to take actions to reduce my fuel consumption and my carbon emissions. That's the ideal thing. If this doesn't result in any change of behavior, you say, okay, it's just another charge. We'll sort of funnel it through, and the consumer can pay in the end. Well, it's all the aim of putting shipping emissions into the ETS has been completely nullified. Now, short of altering the fuel you use on your vessel, either in whole or in part, 2 things which you could do to reduce fuel consumption and thereby reduce carbon emissions. You could do slow steaming. The only problem is that this breaches the implied obligation to proceed with reasonable dispatch. You could do some rerouting. This breaches the obligation to proceed in the direct and usual geographical line between the port of loading and the port of destination. So you'd need clauses not only in your voyage charter, or also in your time charter, to deal with these potential breaches. But you need to get them incorporated into your bills of lading, so you don't get hammered for the fact that you've slow steamed and you haven't proceeded with reasonable dispatch, and the bill of lading holder then is making a claim against you for the fact that they've suffered loss as a result of the delay in performing the voyage. What about the future? An important part of the ETS is there's going to be a review in the light of what is happening in the IMO. There are provisions whereby the Commission is to review the ETS's consistency with possible future market-based shipping measures. The aim is to avoid double burden. Article 3(g). There's going to be a review of the directive in the light of any future adoption by the IMO of a global market-based measure to reduce greenhouse gas emissions from marine transport. And then the Commission must present a report to the Parliament and Council within 18 months of that measure, and to examine it in the light of the EU's ambition, in the light of the objectives of the Paris Agreement, the overall environmental integrity, including comparing the IMO measure to the provisions of the ETS directive, and similarly any issue related to the coherence between the EU ETS and what the IMO come up with. So it could be altered. If the IMO doesn't come up with such a measure by 2028, there's another report the Commission can present, in which case it must examine the need to apply the allocation of allowances in respect of more than 50% of the emissions from ships performing voyages from a port of call outside the jurisdiction of a member state and a port of call outside the jurisdiction of a member state. So basically extra EU voyages in the light of the objectives of the Paris Agreement. In particular, the Commission shall consider progress at IMO level and examine whether any third country has a market-based measure equivalent to this directive and assess the risk of an increase in evasive practices, including through a shift to other modes of transport or a shift to port hubs outside the European Union. And then, where appropriate, either of the reports, which we've been contemplating, is to be accompanied by a legislative proposal to amend the directive. So we could see some amendment in the light of this. MEPC 83, 7th to 11th of April 2025 at the IMO. Plans for a carbon levy got abandoned, but there was a majority vote, 68 in favour, 16 against and 25 abstentions, which approved midterm greenhouse gas reduction measures, which would involve a new fuel standard for ships and a global pricing mechanism for emissions. These measures are set to be formally adopted in October 2025. They should enter into force in 2027 and become mandatory for large ocean-going ships over 5,000 gross tons, and these are the ones which emit 85% of the total CO2 emissions from international shipping. So the draft regulations would require these ships over 5,000 gross tons to comply with, first of all, a global fuel standard under which they must reduce over time their annual greenhouse gas fuel intensity. That's the amount of greenhouse gases emitted for each unit of energy used, and that's calculated on a well-to-wake approach. So that is going to take account of some of the production energy emissions involved in using methane. Secondly, a global economic measure whereby ships emitting above those thresholds will have to acquire remediable units to balance deficit emissions, but those who are using zero or near zero reduction technologies are going to be eligible for financial rewards. So what is not certain, I think, at the moment, first of all, is this actually, will this get approved in October? I think it's likely it will, but I don't think it's by any means a done deal. But if it is, I think the Commission are going to have to start thinking, how does this interact with our EU inclusion of shipping in the ETS? Is this going to result in the possibilities of a double burden on ship owners? In particular, these proposals of the IMO say nothing about any pass-through of the costs of compliance with these requirements to time charters. It's all going to be, that would be something which is a cost on owners, and it's up to contractual measures between owners and charterers to decide how that works out as between themselves. So that's what that concludes my first presentation, and now I am going to come back, and I can see you, and I can take any questions which you may have, and hopefully I might be able to answer some of them.
So there are some questions on the chat box. Do you want me to read them out?
Now, Now, chatbot, is this chat with everyone? Right, okay, so I think what I'll do is I'll go through the in-call messages. So the first question is, can EU sanctions lead to the detention of one of the vessels of the fleet of ship managers, despite such vessel detained been detained having paid the CO2 allowances? Can the right of detention be extended to a twin vessel or to any other vessel of the fleet? I think if you say I think the answer is yes, it can be. It depends what vessels are under the management of a particular ship manager. But as I read the sanctions requirement, that risk of sanction would apply to all the vessels under the management to whom a delegation has been made to that particular ship management. Now, about the latest carbon levy allowance, well, I've only given you a very brief look at that. It's a lot more complicated than my brief summary, but it does mean that you're going to have to end up paying money unless your ship starts reducing its carbon emissions. And I think also, I think it's not just carbon, it's greenhouse gas emissions. So it's going to, don't think just going on to LNG is going to be a great solution, because there's the methane allowance, methane emissions from LNG, particularly on a well-to-wake basis, which are going to be subject to the reduction requirements under the IMO. So I think it's probably at the moment, I can't really go into any more detail than what I put up in my slide. So what is being proposed is by the IMO would apply to everybody who's a member of the IMO. Now, the IMO is made up of member states. The EU is not a member of the IMO, it's an observer, but the individual EU states are members of the IMO, and they would be required to put into their national law provisions relating to the obligation on ship owners to reduce their greenhouse gas emissions. Let's check if there's any. Well, I think India's trade context is at the, as regards the IMO proposals, they are going to affect India as much as any other IMO state, and India will have to do the necessary implementation through its domestic legislation of the IMO proposals once they get approved, as it does with every other bit of IMO regulation. And secondly, as regards the EU, if you've got a voyage from India through to the EU, the amount of allowances which have to be bought by the shipping company is going to be 50% of the amount of carbon emitted on that entire voyage, and there would be that would be a price of you find the current price of carbon and then apply that to the carbon emission on that voyage, and that gives you the amount of allowances you have to purchase and then to surrender in the following year by 30th of September. Remember also that for the initial period, there is a sort of a further phasing in, so you wouldn't have the full amount of the costs, the allowances to be surrendered for the first 2 years. Now, there's a question about if it would be good for Bharat. So there's a few things that now Dr. Mitra's question is, would it be good for Bharat if it is notified by IMO? I'm not. Perhaps you could give me a bit. Right, the carbon border adjustment mechanism is a different thing altogether, but it is part of the EU's general attempt to cut down on emissions, and in particular, it's trying to equalize the position between the EU states and who are subject to the ETS in particular. I don't think the carbon border adjustment mechanism actually affects shipping. I think that's something, the actual act of shipping is entirely under the ETS, but it may be that goods which are coming in through ships, they have to pay something on the carbon border adjustment mechanism, which is aiming at equalizing the position with regards the treatment of carbon made in manufacturing those goods from the treatment, say, of cement and steel, which is being made in the EU, which is subject to the emissions trading scheme. Economically, I don't know how it has impacted the trade between India and EU. I would have thought it's probably going to make goods coming from India more expensive if they're going into the EU. Question about whether sanctioned ships will be able to use their credits. Yes, I think they would be, because one of the sanctions is that you're going to have you have to pay up under the credits which you should have been buying and haven't. If you're a sanctioned ship and you've been and those credits have been actually purchased and by your ship manager and they have been surrendered, then that's all right, but you're still under those sanctions. And I think there's an additional sanction of I think it's €100 per carbon, €100 per ton of carbon emitted. That's an additional penalty, and I think you would still be subject to that penalty. And that's something I find quite worrying and rather unfair. Carbon credits. Well, I'm not sure about I mean, you can participate in, if you're in the ETS, you can participate in trading your carbon credits. How that is going to happen in relation to ship owners' credits, I don't know, but it's something which has been suggested as a potential advantage. I don't know, but you can. Right. Now, I wonder if we're coming to the stage where it might be good to have perhaps a brief 5 or 10 minute break, and then we'll perhaps proceed to look at the second subject, which I'm going to be talking about, which is the implications of the Grand Amanda time charter case, which came out on the 31st of July this year. So, Preksha, what do you reckon? This is a good place to have a break?
Yes. Yes, so we can break for 5 minutes and then we can be back.
5 minutes is good. Okay, I will get a different thing for my share. Okay, thank you.
Thank you, sir.
Now I'm going to take that. Yes.
Sir, am I audible?
Hi.
Yes, sir.
I I presume, are you recording the event?
Yes. Yes, sir.
Good.
Yes, sir.
Yes, that's great.
Yeah. So you may begin if you are ready.
Yes, I'm ready. So we're now going to look at our second presentation, which is on the recent case of the Grand Amanda, 31st of July of this year. Mr. Justice Henshaw, and it's about the implied indemnity under a time charter and what it covers and what it doesn't cover. And I'm going to go wrong one. Let's go here. Grand Amanda. And excellent. That should do it. So I'm going to start with just a brief definition of what an indemnity is. This is what the House of Lords said in Sheffield Corporation and Berkeley, and they adopted a previous statement made in the Court of Common Pleas in Dugdale and Lovering, and this is that statement. When an act is done by one person at the request of another, and the act is not manifestly tortious to the knowledge of the person doing it, and such act turns out to be injurious to the rights of a third party, the person doing it is entitled to an indemnity from him who requested that it should be done. So if I ask you to do something for me and you do it, and then that person gets into difficulties, costs incurred in connection with the rights of a third party, they can get a recovery from me of what they've lost by having to make a payout to the third party. Now, I'm just getting right. Now, yeah. With a time charter, if ship owners comply with the charterer's employment instructions, they may be entitled to an indemnity either because there's an express provision in the charter party, like in the bull time, or one which is implied by law, an implied indemnity. And that was recognized in the Court of Appeal's decision of the Island Archon. Generally, indemnities are not implied into voyage charters. The case of the Sea Joyce is an example of non-implication. And more recently, the Eternal Bliss, where at first instance, Mr. Justice Andrew Baker decided that the costs of having a cargo claim in China in relation to damaged soya beans could not be recovered by way of any implied indemnity, but could be recovered because of as consequential damages of a breach of contract in the charterer's failure to discharge the cargo within the required lay days. Obviously, that then gets overruled by the Court of Appeal, but no implied obligation, no implied indemnity. And I think the thing is, there's much less scope for orders and instructions in voyage charters than there are in time charters. A trip charter is somewhere in between, and it really depends on what's going on in the trip charter. Are you actually, it may be for a single trip, but are you getting a variety of possible ports you could be sending the vessel on its trip, a variety of different cargoes? If you've got those choices which you can be making, then the indemnity can be operated and it can be implied. Indemnities don't normally get implied in these circumstances when the ship owners incur damage or expense or liability to third parties as a result of complying with orders which the charterer is entitled to give, or where the owners incur damage or expense of complying with orders which the charterers are not entitled to give, but owners are not obliged to refuse. But actually, we will see that there is quite a bit of scope with a time charter for that, for the ship owner to get an indemnity where you've had legitimate orders and there's been no fault by the charterers. And as a result of following those orders, you have suffered loss. When the owner is entitled in principle to an indemnity, it doesn't necessarily mean that he will get an indemnity in all circumstances in respect of all losses. First of all, the owner will be entitled to an indemnity only if the loss claimed is directly the result of the employment order. The fact that your loss wouldn't have arisen but for the order is not enough. You've got to have an unbroken chain of causation between charterer's order and owner's loss. So if you've got intervening negligence on the part of the owner or the master, this will break the chain of causation and you won't be able to get an indemnity. Now, it's the second limitation, which is the more controversial. It's the one which we are considering in the grand demander. Even if the loss does flow directly from the charterer's employment instruction, not every loss which occurs as a result is recoverable. And Mr. Justice Lloyd in the Aqua chart.
Excuse me.
Yes.
So your slides
Yes?
are not changing. It is on the first slide still.
I don't know how to operate it then, so I'll have to. Thank you for telling me that. I'll have to. Now, if I try a different way, no, I'm going to have. If I go,
You'll have to go to the slides on the left. Yeah.
Is that working now?
Yes, sir.
Right. Okay. So, apologies for that. I'm still not completely used to Google Meets on this, but so that's that one. I think we're on slide 5. Thank you, Prector. I was charging ahead in blissful ignorance of that. So I think that works now. So what Mr. Justice Lloyd was saying, it's of course well settled that owners can recover under an implied indemnity for the direct consequence of complying with the charterer's orders. But it is not every loss that can be recovered. For example, the owner cannot recover heavy weather damage merely because if the charterer ordered the vessel on a different voyage, the heavy weather would not have been encountered. The connection is too remote. Similarly, the owner cannot recover the expenses incurred in the course of ordinary navigation, for example, the cost of ballasting, even though in one sense the cost of ballasting is incurred as a consequence of complying with the charterer's orders. The same considerations apply in the present case. The costs of transshipment were an ordinary expense incurred in the course of navigation. Now, a case called the Athanasia Komnenos is a case where the ship gets damaged because a cargo of coal ignites because there's a mixture of air and methane gas. There's been no breach by the charterer, but the indemnity can be claimed because that cargo has been loaded pursuant to the orders of the charterer. As Mr. Justice Mussell says, it seems to me perfectly possible to have a loss which is caused by a shipment of cargo having certain properties, even if the properties of the cargo in question are no different from those of other cargoes of the same description. In the present case, if one asks the question and you eliminate the possibility of ship owner's fault, why was there an explosion? The answer is because there was methane in the hold. Then you say, well, why was there methane in the hold? Because the time charterers called on the vessel to load coal. That's enough to found an indemnity without proof that the coal was in any way unusual. So you don't have to have breach by the charterers. Now we come to a case called the Island Archon, Court of Appeal decision 1994. You've got a time charter. There's a voyage to Basra. Basra is within the trading limits. Unfortunately, in May 1980, at the time the order to go to Basra was given, there was something in existence called the Iraqi system. Shortages were recorded against cargoes delivered even without any physical damage. It's basically a corrupt form of getting foreign revenue by manufacturing fake cargo claims. There's a clear causal link. You ordered us, you the charterers ordered us to ship cargo to Basra. We suffered a loss in having to pay a manufactured cargo claim. Now, well, 9. Now, there's no, what might stop that happening though, and this is not what is, this is a different type of situation. There would be no indemnity in respect of risks assumed by owners at the date the charter was concluded. And there are dicta by Lord Justice Evans, who gave the principal judgment in the case, that the result in the Island Archon, whereby the ship owners recover by way of indemnity, supposing the Iraqi system had been in operation at the time the charter was concluded in December 1979. It wasn't in operation at that time. So you couldn't say that the ship owners had accepted the risks of that system when they concluded their charter party, knowing that they would know that there's a risk that if you get ordered to Basra, you are going to end up with manufactured cargo claims being resulted against you. If that had been the factual case, Evans thought that there would be an argument that the ship owner would have accepted the risk of that system and would not be entitled to an indemnity. On the facts, the Iraqi system was not in operation at the time of the charter being concluded in December 79. There's no acceptance of this as a trading risk of going to Basra. The risk hadn't materialized at that time. And that is really what the Grand Amanda is going to be about, is what risks can be said to have been assumed by the owners at the time the charter is concluded. Now, foreseeability of a risk at the date of the charter's conclusion is an important consideration. It's not the only one. In the Demetrius L, one of the factors was that there's actually a specific clause covering the US transportation tax actually in the charter party. But also there's the finding that this would be a normal trading incident when going to the US. It's not something which had been brought into operation after the date of the time charter's conclusion. Another example is the case of the Kitzer, where you have a voyage going from cooler waters to a port in warm water, and you have a wait during those warm waters, and you you get barnacles on your hull, and that then results in a loss to the ship owner who's got to get those barnacles off. That susceptibility to marine growth in warm waters, in ports within the trading limits of the charter, is something which is a risk assumed by the charterer, the ship owner. It's something you could have known, you knew about that at the time you concluded the charter party, and you accepted that there would be the possibility of trading to those warmer water ports, and that there may be delay waiting there. Now, the Grand Amanda, it's a time charter trip concluded in 2014. 2014 is going to be the key date in assessing what risks the ship owners may have accepted at the date of the charter party. It's a time chartered trip, but there are choices which can be made. There are orders which can be given. Lawful and harmless cargoes, so you've got a very wide choice of what cargoes you load, and you've got a very wide choice of where you load them, where you discharge them, via the east coast of South America to the Far East. Charterers make these choices. First of all, we're going to go on a voyage from Uruguay to China, and we're going to load soybeans. Soybeans can frequently involve claims of inherent vice. Problems with soybeans arise in the eternal bliss, and also in the case of the Thai prize. When the cargo discharges in China, it's clear that it's damaged. And for the purposes of the litigation and the preceding arbitration, it is accepted by both sides that this damaged cargo was subject to inherent vice. The bill of lading is subject to the Hague Rules. There is a defence in the Hague Rules of inherent vice, Article 4.2m. So you would expect, if a cargo claim is made against you in another jurisdiction in relation to the damage to the cargo, the ship owner would have a perfectly good defence and would not have to pay anything. Owners Club fight the claim in China, but in 2018 a judgment is given against owners, and after 2 rounds of appellate proceedings in China, that is confirmed. The question is, can the owners recover the costs of that judgment from the trip charterers based on the implied indemnity? There is no breach by the time charterers, but owners are saying, you ordered us to load this cargo, which was soybeans, and that cargo turned out to be an unstable cargo, one which was going to be subject to inherent vice. And because of that order, we end up with a liability which we have to pay because we end up discharging in China, and we have an adverse judgment against us in respect of the physical damage to that cargo. Charterers say, well, actually, what you've got is a risk which you've accepted of going to China, Far East, any port in the Far East, and the risk is that at the time of the charter party in 2014, when it was negotiated, it was generally known that the Chinese courts would not allow a defense of inherent vice to be raised in cases of physical damage to cargoes discharged in China. So that's basically setting out the way the battle lines are in this case. The arbitrators find for owners. Now, this case has also got a slight wrinkle in that the interclub agreement is incorporated, but it is regarded as being irrelevant because the interclub agreement, according to the arbitrators, does not cover judgments, but only settlements. And we're talking about a judgment which is being sought to be recovered by owners from charterers. But that means that the focus is on recovery of losses through this implied indemnity. Mr. Justice Andrew Baker, interestingly enough, he's the judge involved in the Eternal Bliss case, the marriage case, which also involved soybeans, which got damaged when they entered, eventually came to be discharged in China. He gives leave to appeal on this question. Where liability is wrongly imposed on an owner by a foreign court following shipment of a lawful, harmless and permitted cargo that is affected by inherent vice, can the owner recover that liability from a time charterer under the general implied indemnity? He then says, I note in particular there seems to be both what? First of all, what may be a contradiction in the reasons in that the arbitrators appear to accept or proceed on the basis that the cargo was a lawful and permitted cargo, inherent vice notwithstanding, and that they also say that it was a cargo outside the limits of the charter party. And B, what may be a misunderstanding of the island Archon, which did not turn on the near inevitability of a cargo claim under the Iraqi system, but on the fact that the existence of that system and thus the risk of suffering loss under it was not notorious when the cargo was concluded. Evans J. expressly contemplated that otherwise the result might be different, and an appeal here may provide an opportunity for that to be explored and tested in a case where it will be determinative. 31st of July of this year, Henshaw J. upholds the tribunal's finding. He notes, first of all, there's no finding that the inapplicability of the inherent vice defense in the Chinese courts was notorious in 2014. Now, if that's right, that really ought to be just the end of the matter. Now, Henshaw goes on to say, further, the tribunal in the present case made no finding that the risk of incurring liability in the PRC due to cargo damage caused by inherent vice was foreseeable or foreseen when the charter party was entered into. And it seems unlikely that it was. To the contrary, in reasons at paras 136 to 137, the tribunal rejected charterers' submission regarding foreseeability on the facts of the present case. It was not self-evidently foreseeable that inherent vice would fail to provide a defense in the PRC proceedings. Well, up to a point, Lord Copper, as Evelyn Waugh once said, in other words, meaning the word no. I don't think the tribunal actually found that. If we go to the key part here, which is actually in paragraph 137, this is actually what the tribunal say. In our view, the alleged offences were without merit. Charterers' liability to cargo, owners' liability to cargo interests in respect of the damaged Montevideo cargo was not an ordinary cost or risk associated with the performance of the chartered surface. It was not one of the broad range of physical and commercial hazards which are normally incidental to the chartered surface. It was a loss arising from a cost or risk which had not expressly or impliedly been agreed in the charter. For such liability, Grand Amazon was not being remunerated. A cargo with a propensity to self-heat is outside the limits of the charter party and outside the kind of risks which Grand Amazon agreed to bear under the charter party. Now, that is actually taking a rather different view from what Henshaw says. There's actually nothing about foreseeability here as to whether is it foreseeable in 2014 that the Chinese courts are going to reject a defense of inherent vice if you end up with a cargo claim involving in physically damaged cargo there. They're actually saying that if you've got risks arising out of a propensity of a cargo to self-heat, that is outside the type of risks which the owners have agreed to bear. Now, that's a much narrower view of what the limits on the implied indemnity, which was stated in the Island Archon, that somehow you have to hone things down to a division between owners' risks and charterers' risks before you even get to any question of foreseeability. Secondly, and I think this is a perfectly good point, the incorporation of the interclub agreement does not provide a complete code for cargo claims. So it doesn't oust the possibility of cargo claims which are outside the ICA being dealt with under the implied indemnity. And then the third point, and I think this is where Henshaw really upholds the charterers, the tribunal's view about the division between charterers and owners' risks. As owners point out, the risk of a microbiologically unstable cargo resulting in cargo damage and liability arises directly out of the orders of charterers, who have discretion over the particular cargo selected for shipment and the selection of ports of loading and discharge. Over those matters, the owners have no right of control beyond the confines of the charter party. There is no proper basis on which to fault the tribunal's conclusion that the risk of loss, in fact caused by the shipment of a cargo, such as the Montevideo cargo with particular self-heating characteristics, is not one ordinarily accepted by the owners. And what about the Island Archon, about the Iraqi system and the fact that there the Iraqi system was not in existence when the charter was concluded in December 17, and so it's not a risk which the owners could have been taken as having assumed at the date of the charter party, which gave a discretion to charterers to order the ships to go to various ports, including Iraqi ports. The tribunal deal with this. Put shortly, any ship ordered to discharge general cargo in Iraq was almost bound to have cargo claims made against it, and to have those claims taken to court locally, leading to adverse judgments, regardless of whether there was any actual shortage or damage or otherwise any liability on the ship under the bills of lading. As regards the carriage of general cargoes to China in 2014, the position was very different. Cargo claims were not almost inevitable. Cargo claims were only brought in respect of damaged cargo. The risk of unjustified cargo claims was not a risk which had been accepted by Grand Amazon. Well, there's is this really a valid distinction? Going to Baughen, there's no physical damage, but in the Grand Amanda there was. Is this a valid distinction? Why is going to a port where you're going to have manufactured cargo claims brought against you, even though there's no physical damage, why is that different from going to a port where you can get cargo claims against you when you deliver damaged cargo, but you would you should expect to be able to defeat that on the ground of inherent vice. And I wonder whether they actually, this actually answers the particular question which is posed in the question which Andrew Baker agreed should be remitted under the Section 69 appeal. And I think this has implications for what we would decide. We were talking about as regards the EU ETS scheme. And I was saying that, you know, looking at the Demetrius L, this is going to be regarded as ordinary trading risks, which ship owners accept. They're foreseeable at the time you complete a charter party, conclude a charter party, and you allow your ship to be ordered to trade within and in and out of the EU. Now, in the context of the Demetrius L, the US transportation tax was regarded as an ordinary incident of trading to the US. Are we now going to say that, based on the approach of Henshaw in the Grand Amanda, oh no, that's actually not right, because this is the risk of incurring a liability for EU allowances, actually that's a charterer's risk, particularly given the the pass-through provisions which enable owners to seek recovery of the costs of surrendered allowances in the courts of EU member states. Will there be an appeal? Did Henshaw J answer the question which was actually remitted? I don't think he did answer the question, but I think the key question actually is, was it notorious in 2014, when the charter party was made, that courts in the People's Republic of China would not recognize a defense of inherent vice when they were presented with a claim for damaged cargo? I don't think there is anything specifically said about that issue in the tribunal, and when Henshaw seems to suggest that there was some sort of positive finding that there wasn't, it wasn't notorious in 2014. I don't think that's borne out by the passages he cites from the tribunal's reasons. I haven't seen the actual full award. It would be very interesting to see what the charterers actually say and how they justify it, to say that this situation was notorious in 2014. So I'll just go back a little bit, because I'm just going to remind you of the particular question. Where liability is wrongly imposed on an owner by a foreign court following shipment of a lawful, harmless and permitted cargo that is affected by inherent vice, can the owner recover that liability from a time charter under the general implied indemnity? I wonder if that has been correctly answered by Henshaw, particularly in the light of what Mr. Justice Andrew Baker notes, particularly as regards B, about the potential misunderstanding of the island Archon. It did not turn on the near inevitability of a cargo claim under the Iraqi system, but on the fact that the existence of that system, and thus the risk of suffering loss under it, was not notorious when the charter was concluded. it would be interesting to know exactly how much you have to prove about what is not notorious. It's perhaps with the Iraqi system, it's probably a lot easier to do, but I suppose with the position in the Chinese courts, you're going to have to go find out when, when does inherent vice first get raised before the Chinese courts and get rejected. I don't know whether that type of evidence was put before the tribunal in the arbitration. So maybe there'll be an appeal, maybe there won't. But anyway, those are my views on that case. I think it is potentially actually quite an important case. So I'll have a look in the chats and see if there's any questions. Question I've got here is, does the Grand Demander set a new standard of the material scope of foreseeability? Foreseeability is now linked to the notoriousness instead of the risk associated to the common practice in the trade. I think it's the other way around. I think foreseeability is probably what people thought prior to the Grand Demander, whereas now you actually are looking at what type of risk are we dealing with? Is it a charterer's risk or a ship owner's risks? And I'm not sure that's the right question. Okay. Okay, Belen, thanks.
Thank you, sir, for that insightful and thought-provoking session. If anybody else has any questions, please go ahead and put them on the chat box, or you could raise your hands and then unmute yourself subsequently.
And of course, if anybody is inspired to raise any questions resulting from the Grand Demander, you can always drop me a line at my Swansea University email. That's no problem. I hope I haven't been too rude about Mr. Justice Henshaw. Thank you. I was, I think it was it was either one or two of my case notes were referred to by charterers, and Henshaw very politely said I was wrong. I've got a great record of being cited in cases nearly all the time. Mr. Baughen is wrong, although it weirdly, as in the introduction, in the corporate liability case in Canada on Nevson, I actually ended up getting cited briefly in the majority judgment and the minority judgment. Very odd, but yeah, at least I didn't say I was wrong.
Thank you, sir. I don't think there are any more questions as of now. Before we close, there is a feedback form for all of the participants present here. Please fill that out so we can bring future webinars like this. And sir, on behalf of the entire organizing team and all of the participants here, thank you so much for sharing your expertise and knowledge with us today. And to the rest of you, to all of the audience, thank you so much for being engaging and putting forth your questions before sir. So we hope for future collaborations. I will reach out to you with the mail soon for the same. And to the participants, we hope you leave with practical insights, fresh perspectives, and maybe even a little extra motivation to dig deeper into the maritime and environmental law. Thank you for joining us, and we look forward to seeing you at our next event. Have a great evening. Thank you, everybody. Thank you so much, sir. It was a pleasure having you. And
I very much enjoyed doing this presentation. Thank you for organising, Preksha.
thank you, sir. Thank you so much. I will connect with you in a few hours. Thank you, sir.
Okay.
Yes,
Okay. Bye bye, Karan.
bye bye, sir. Okay.